Okay, so the first part of the notes say, thank Mark for kind introduction. No. Good morning, everybody. It's nice to be here again as a speaker. It's been quite a while, I think, since the last time I was up here. When I asked my assistant, Jackie, who many of you know, to type up some speaking notes for me for this morning, I asked her if she could remember the last time that, in fact, I had spoken at the firm seminar. And Jackie didn't have an answer for me at that moment, but when she'd finished typing and brought me the notes, she said, you know, I've got no idea the last time when you spoke at the seminar was, but I can tell you that the size of the type that you now require in order to be able to actually see these notes has risen exponentially since the last time you were here. So I think that's an indication of how long it's been. But before I get started into my talk, I'd like to thank my colleague Carla Nassar for all the work that she's put in on the paper, and you'll find it on the website. And thank you very much, Carla. My topic today, as Mark indicated, is constructive dismissals, and in particular, the impact of a recent Ontario Divisional Court decision in a case called Kafka and Allstate Insurance. That case dealt with a number of points, but the particular one that I want to deal with was the ability of an employer to make fundamental changes unilaterally to a contract of employment. Now, to appreciate the significance of Kafka, you first have to look at two prior cases on the topic. And the trilogy of decisions started with a Supreme Court of Canada decision in a case called Farber and Royal Bank back in 1997. And in that case, the plaintiff, David Farber, had been a regional manager for the Royal Bank, and he supervised some 400 real estate agents in 21 offices. Now, those offices in 1983, which was the last year he held the position, their sales totaled more than $16 million. And in 1984, RBC underwent a major reorganization, and they eliminated all of the regional manager positions that they had. So Mr. Farber was offered a job as a manager at a single branch, and this was the same branch at which he had been the manager some 4 promotions ago. The branch was one of their poorest performers and was one that they had actually considered closing at one point. So had Mr. Farber accepted the position, he would have been supervising only about 20 real estate agents instead of 400, and the sales volume at that branch was only about $600,000 a year in 1983 compared to the $16 million from his regional position. So he was given a 1 month's notice to accept this change or resign. So clearly this was a demotion for Farber, both from a status perspective, and it certainly looked like he was going to take quite a hit financially as well as a result of the change. So he didn't accept what he viewed as a demotion, and he took the position he had been constructively dismissed. Now, the Supreme Court found that indeed he had been constructively dismissed, and in doing so, they set out the following test for determining, in fact, when an employee had actually been constructively dismissed. And the court held that a constructive dismissal occurs when an employer makes a unilateral and fundamental change to a term or condition of an employment contract without providing reasonable notice of that change to the employee. Now, that contract didn't have to be in writing. It could simply have been the terms and conditions under which they had been employed. But what's important for our purposes, and certainly for the Kafka case ultimately, is the last part, the reasonable notice part. So the court's decision had been interpreted to mean that an employer could unilaterally make material changes to somebody's terms and conditions of employment so long as they provided reasonable notice of that change. Now, how much notice was required to constitute reasonable notice? That varied depending on the circumstances of each particular case. Now, Supreme Court of Canada decisions are binding on all lower courts, so it was quite surprising, certainly to employer counsel anyhow, when the Ontario Court of Appeal issued its decision in a case called Wronko and Western Inventory Service in 2006. And the surprise from that case was because it appeared to eliminate that possibility that an employer could make that fundamental change by providing reasonable notice. So in Wronko, the plaintiff had an employment contract that provided him with 2 years' salary in the event he was terminated without cause. And that agreement had been negotiated late in 2000, which was about a year before a new president arrived on the scene at Western Inventory. And it was safe to say that that new president did not like the termination provision in Mr. Wronko's contract. So he set out to change that provision. And in 2002, the new president sent Wronko a new contract, which provided for only 30 weeks salary payment in the event of his termination without cause. Now, Wronko refused to agree to that change. And so the president wrote Mr. Wronko a memo. And in that memo, he purported to give him 2 years' notice that the termination provision in his employment contract would be changed to a formula that was 3 weeks per year of service to a maximum of 30 weeks' pay. Now, Wronko still refused to agree to the change, and he advised the president that, in fact, he didn't agree to it. So Mr. Wronko continues to work there, and 2 years pass by, and we get to 2004. At that point, the president sends Mr. Wronko another email, and he attaches the email from 2 years previous, as well as a contract that he describes in the email as a go-forward agreement. Now, the agreement contained the termination provision that limited the pay in lieu of notice to Mr. Wronko. It's capped it at 30 weeks. So in the memo, the president stated that since 2 years had passed, the new contract was now in effect. Now, Wronko was asked to sign the contract and return it, and at the end of the email, the president advised Mr. Wronko that if he didn't wish to accept those new terms, then the company didn't have a job for him. So Wronko, not surprisingly given his earlier stance, didn't accept the change, and he responded that he understood his employment to be terminated. So the company's position was that Mr. Wronko was only entitled to 30 weeks' pay, as he'd been given 2 years advance notice of that change being implemented. So there wasn't any dispute that the amendment to those termination provisions constituted a material change. The issue was whether or not the company could actually effect that change by providing reasonable notice of it. Now, the Court of Appeal then found that Wronko had been constructively dismissed. And the Court of Appeal went on to distinguish the Farber case, saying that the court in Farber was faced with a situation where the plaintiff had been given a month's notice, that he had to accept the demotion or resign. The plaintiff refused to accept that new position and sued for wrongful dismissal. So the Court of Appeal in Wronko said that the Farber decision had to be interpreted in light of those facts. The Supreme Court in that case was not purporting to outline the rights and obligations of the parties in circumstances where an employee registers an unequivocal rejection of an intended fundamental change to the terms of his employment, and where the employer permits him to continue working according to the existing terms without giving notice that refusing to accept those new terms would result in his termination. And the court said those are the facts in Wronko. That was not the case in Farber. Farber doesn't apply. And so the Court of Appeal went on to say that having been made aware of Wronko's opposition to the new contract in September of 2002 and his continued opposition thereafter, they had two choices as an employer. One, they could advise Wronko that his refusal to accept that new contract would result in his termination and that reemployment would be offered on the new terms. And if Western were to take that position, the termination provision in the 2000 contract would be triggered, so the 52 weeks pay. The alternative that the court identified for Western Inventory was that the company could accept that there was no new agreement and that his employment would continue on the existing terms. So under either of those alternatives, there was no ability for the company to get out of the 2-year termination payment that the original contract provided for. And so the court said that having failed to choose the first course of action, Western had to be taken to have acquiesced to Wronko's position and to have accepted that the terms of the existing contract with respect to termination remained in effect. So The court held then that Western's decision to terminate Wronko in September of 2004 carried with it the consequence that he got 2 years termination pay pursuant to that December of 2000 contract that he had signed. So that decision received a fair bit of criticism, as it appeared to go against what the Supreme Court of Canada had said in the Farber case. Now, what the Wronko decision appeared to do was eliminate that possibility that an employer could make fundamental changes to an employee's terms and conditions of employment, so long as it gave reasonable notice of those changes. So earlier this year, the Divisional Court had the chance to revisit Wronko, and the decision came out early in 2012, and that was in Kafka and Allstate Insurance. And so the Divisional Court took the opportunity to clarify the situation, and in fact ended up affirming the law as we all thought it was, following the Supreme Court of Canada's decision in Farber. So the Kafka decision involved an attempt by a group of about 100 former Allstate insurance agents to have an action for constructive dismissal certified as a class action. Before July 2007, Allstate had operated in a way that each insurance agent's operation resembled in some ways their own business, as opposed to them being an employee of Allstate. Each agent had an employment contract with Allstate, but they each had their own office and sold insurance products through these offices, which were termed neighborhood office agencies. Each agent was responsible for renting space themselves, for hiring and training staff, and perhaps most importantly, they were paid commissions by Allstate for signing up new customers and signing up renewals from existing customers. But in 2007, Allstate decided to change that business model. There would no longer be neighborhood office agencies. The operations were going to be consolidated into larger offices where these agents would work. And so under this new model, the agents were going to be more like typical employees rather than these business managers that they had been before that. And not surprisingly, their compensation system was also changed. And they would no longer be paid commissions based on their own individual performance. Rather, they were going to be paid a bonus based on the performance of the entire office that they were now located in. There was still an individual performance component, but it was kind of dwarfed by the overall office performance criteria. So the agents were notified of these changes by way of 2 letters in July of 2007. There was a generic letter that was addressed to all of the agents, and then each agent received their own individual letter, which set out the specific terms applicable to their own situation. There was also a video presentation that was made to everybody on the changes as well. And the changes were stated to become effective in September of 2009, so there was over 2 years of notice that was provided before these changes were to become effective. Now, the agents took the position that they had been constructively dismissed and argued that they were entitled then to termination and severance pay under the Employment Standards Act. And because there were so many of them, and because they thought the fact situation that was applicable to each of them was basically the same for all of them, they sought to have that action certified as a class action. And that class then would have been all of the Ontario agents whose employment ended between the time they were given notice in July of 2007 and when the changes were actually implemented in September of 2009, and who didn't get termination and severance pay. So under the rules, you have to get a class action certified, you have to bring a motion before a judge who has the authority then to either certify it or not. And so the plaintiffs brought a motion before Madam Justice Horkins, who denied the application to have it established or certified as a class action. She found that there were no common issues between the cases of each of these former agents. And she also held that there to determine whether in fact there'd been a constructive dismissal, you had to look at the facts of each case, and so there had to be an individualized analysis made for each agent. So the plaintiffs appealed that decision to the divisional court, and the divisional court upheld Madam Justice Horkin's decision and refused to certify the claim as a class action. Now, in dismissing the appeal, the divisional court had some helpful things to say for employers, I think, on the question of constructive dismissals and the impact of the Wronko decision. Now, the court dealt with about 6 different questions in in their appeal, but on this particular issue, they framed the issue through the following question: could Allstate make material changes to the class's employment terms by giving 2 years' notice? So this sounds a lot like what Western Inventory had tried to do in Wronko, in which the Court of Appeal had said that it could not do. In Kafka, the motion judge ended up following the Supreme Court of Canada's decision in Farber and held that a constructive dismissal occurs when an employer makes a unilateral and fundamental change to a term of an employment contract without providing reasonable notice of that change to the employee. And on appeal, the former Allstate agents said that that characterization was incorrect. They argued that an employer could not effect unilateral and fundamental changes to the employment contract with any amount of notice. And they relied on the Wronko decision to support that argument. And the divisional court then had to deal with Wronko squarely, and basically they held that in Kafka, they said, well, these circumstances are different than Wronko, and so we're going to distinguish Wronko. And basically the way that they did that was that the divisional court said that the general announcement that went out in July of 2007 and the individual letters that were sent to each of the agents by Allstate made it very clear that the changes would be implemented in September of 2009. And so the court went on to say that it could not be said that the employees were allowed to continue working as though nothing was changing. This was clearly a transitional period of 2 years, and it was understood by everybody as such. And so the court said that that decision was very different from the Wronko one. And so they said in Wronko what had happened was that the employer had issued this ultimatum, followed by a period of time in which it had permitted the employee to continue employment after he'd refused to accept those terms. And so they said that in Wronko, that 2-year period between 2002 and 2004 was one of some ambiguity, and it had not been made clear to Wronko that he'd be terminated if he didn't accept the change prior to September of 2004. And so they said, well, in Wronko then, in those ambiguous circumstances, that 2-year period couldn't be considered as notice. And so in Kafka, the court found that there, in fact, was no ambiguity. So they said that unlike Wronko, there could be no suggestion that Allstate was acquiescing to the continuation of the old model of doing business. And they concluded, and I quote, "In short, the Wronko analysis does not change or purport to change the law established by the Supreme Court in Farber, which affirmed that a fundamental change does not amount to a constructive dismissal where the employer provides the employee with reasonable notice of the change." So what employers thought was clear from the Farber case back in the 90s, it would now appear to be the law again. You can argue, I think, that this was something of a gymnastics exercise by the court to get around the problematic decision in Wronko, but the end result is pretty clear, I think. Wronko's now been relegated to the category of an exception to that general rule. So I think the lesson for employers coming out of Kafka is to be absolutely clear to employees if a fundamental change is to be made to the terms of their employment. Set out what the change is to be, when it's to become effective, and ensure that the amount of advance notice is reasonable. If the notice of the change is equivocal, then I think employers may again find themselves dealing with the Wronko decision and that exception. But if it's clear with reasonable notice, then I think employers will be in a strong position to defend itself against an employee's claim that he or she has been constructively dismissed. So I'd like to thank you for your attention. It was nice to have the opportunity to speak this year, and enjoy the rest of the program. Thank you.